Tort law. What is a tort exactly? Well, a tort is a civil wrong. One party does something that hurts or ails another party, and the affected can seek compensation through tort law. Tort law is separate from criminal law in that it seeks compensation more than it seeks punishment, and as such, it has three main goals: compensation, deterrence, and fairness. Compensation is in order to help the injured person recover their losses. Deterrence is to encourage people to avoid harmful behavior, and fairness is shifting the cost of harm onto the person who executed said harm. There are three categories of torts: intentional, negligent, and strict liability. Intentional occurs when someone actually wants to do something harmful. These can be things like battery, defamation, fraud, or my personal favorite, intentional infliction of emotional distress. If you get into an argument with someone and you decide to throw a punch at them in frustration, this is an example of battery, which is an intentional physical contact by one person with another, specifically when it's unconsented to. If you break someone's phone, also out of frustration, anger, or say it's the same person you're arguing with, as it is an object controlled by that person, this is still intentional battery. If you didn't mean to break it, then it's a little bit different. Battery is also different from assault, which is an intentional threat, motion, or show of force, which could cause someone to believe that they are in danger. Negligence is caused by someone who can reasonably said should have known better, but still acted harmfully, though perhaps indirectly. If you throw a punch with the intention to hit someone, and you unintentionally hit the person behind them instead, this is a negligent tort. Unintentionally breaking someone's property in a similar manner may also constitute battery. There are four primary principles of a negligent tort: duty, which is an individual's responsibility to act civilly and with care; breach, which is the failure to adhere to that responsibility; causation, which is the breach that caused the harm in the first place, such as a punch being thrown; and damages, which are the real harm that happened, like a broken bone or a medical expense as a result of the breach. There are also a handful of defenses for negligence, such as excuse, act of God, assumption of risk, or vicarious liability. An act of God is something like a natural disaster or an event no one can control, and assumption of risk is if someone knowingly accepted danger, like knowing you could get hurt when you sign up to box, or walking into woods that have hunting signs posted. Vicarious liability is holding one person responsible for another person's actions, like your boss at a soul-sucking retail job blaming you for not properly training your coworker, who then spilled, broke, or otherwise acted poorly in some way. There's also contributory and comparative negligence. Under contributory negligence, if you contributed to the damage even a little bit, you get none of the damages in question. If you were 1% negligent and the other person was 99% negligent, under contributory negligence, you and them may as well be equally at fault in the eyes of the law. Comparative negligence is a little more lenient, kinder, where your recovery is reduced by how much of the fault was yours. If the fault was 30% on you, then you get 70% of the damages. The third category, strict liability, is unique. There is no intent or negligence required. You're liable even if you weren't careless or intentionally harmful. You can do everything to regulation with the best of your ability and the best of intentions and still get held responsible. So manufacturers face this a lot with defective products. Say you give a Poro snack you've acquired, and the Poro snack is defective or unreasonably dangerous. Even if you and the person who made the Poro snack had no idea there was anything wrong with it, if the Poro gets hurt in any way because of the Poro snack, the manufacturer is liable for the damage. It's worth knowing that some torts can also happen in electronic spaces, dubbed e-torts. These can be things like fraud, trickery used to cheat another person in something like a digital scam, or cyberbullying, which is another great example of an e-tort, as it can potentially be an intentional infliction of emotional distress, and as it's cyberbullying, can only really happen online. Although for the tort to apply, the conduct must be extreme. This is slightly variable, as distress varies from person to person, and what constitutes as extreme may vary. Intentional infliction of emotional distress can also go hand in hand with things like invasion of privacy or fraud, where invasion of privacy is making someone's private matters public, using a person for publicity without their express consent, eavesdropping, or violating someone's right to be left alone. If someone online posts about your personal life with the intention to hurt and embarrass you continuously, Going so far as to make multiple accounts to invade your space and harass you at all hours of the day, then this might be intentional infliction of emotional distress, and it can all happen online. Torts exist because, intentionally or not, harm happens in civil ways. Tort laws exist as a way to mend some of that harm. Thanks for listening, and I hope you learned something today.